The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 925. Coming to you on Monday, the 4th of February, 2019. On this program, I will speak to you on the topic, Court Appointed Mediation. But before getting into the topic, a few preliminary comments. Firstly, condolences go out to all families which have suffered recent bereavements, among them being, first of all, Bishop Elsa Young of Mount Halimat Spiritual Baptist Christian Pilgrim Church of Calico. She lost her husband, Brother Earl Young, and he would be laid to rest in the not-too-distant future. Then condolences go out to the family of our sister Daphne Frederick, particularly to her children, her husband, Brother Bayless Frederick of the legal profession, her daughter, who is a live wire in the legal profession, and other children. We were extremely saddened when we heard of her hospitalization and her having been taken by air to Trinidad and then to Chicago. And then we were devastated to hear that she had died. So, Sister Bennett, our deepest condolences to you and all of the other siblings, and of course to you, Brother Bayless. Unfortunately, I will not be able to go to the funeral, which will take place on Saturday afternoon, because at the very time when she'll be having her funeral rites in Kingston, I will be attending the funeral of one of my cousins, Anton John, who would be laid to rest at the Barley Anglican Church that very same time on Saturday. Of course, on Sunday, we will be laying to rest Sister Doris Jack of our congregation at St. Elizabeth Church, Belmont. And we are so saddened by all of these losses. But the good Lord knows best. He gives and He taketh away. Excuse me. The final preliminary comment. I wish to remind all deacons, deaconesses, lay leaders, pastors, and higher ranks of the Spiritual Baptist Archdiocese of our extraordinary synod, which will take place this week, Thursday morning at 9:30 at St. John's Christian Pilgrim Church at Sion Hill. Very important synod. Among other things, the decisions would be taken to elevate certain persons and to confirm the appointment of our newly elected Archbishop, the Very Reverend Melford Pompey. So don't forget, my brothers and sisters, Thursday morning, we expect the ceremony, the whole meeting, the synod, would go beyond midday, and we are asking the brethren to bring along their own refreshments, since the Archdiocese is in no position to provide refreshments for the folks who would be coming. So bring along your own refreshments. We'd hope to wrap up the session by mid-afternoon on Thursday. Okay? Now, Court Appointed Mediation. What is mediation? Mediation is the process by which parties who have disputes can have those disputes settled without going to trial. Now, if two people have a dispute, by the time they go to lawyers, arrangements could be made in proper cases for those disputes to be handled by mediation. That is, the lawyers may feel, well, look, this is a matter which could be settled because they are family members and for other reasons. Let us try and settle the matter without even filing a case in court. Now, this program is not dealing with those types of mediation before legal action. I am dealing on this program with mediations which occur after legal action has been actually started. So that is, let us consider a situation where two people have a dispute, maybe over land or some other legal problem. They go to lawyers, papers are filed, and the matter goes before the judge for what is called case management. Now, when I say judge, strictly speaking, I should say master, because as most of you would know by now, we have the institution of, I don't want to use the word junior judges, but let me say intermediate judges. That is, persons who have not been fully appointed as judges, but who are appointed as masters to handle various procedures in court in the course of litigation. So when they go before the master at case management, that is the session at which the master is supposed to set down the case for trial. The master would find out from them how many witnesses they intend to call, approximately how long the trial is expected to last, and he would give them directions as to documentation and so forth. But for whatever reason, one party may feel that he or she would prefer to have the matter settled if possible. The rules of court say to the masters or to the judge who is handling the matter, because there are some matters which masters cannot handle, particularly matters called fixed date claim forms. Only judges can deal with those. So the judge or the master might say to the parties, wouldn't you all like to try to have this matter mediated? And he would await the response. Normally, the parties would confer with their lawyers. Sometimes one party may not have a lawyer at all. The judge's intention would be to try and see if the parties would accept a procedure by which the matter could be settled without the need for a trial in court. That is, people going up on the witness stand and taking the oath and giving evidence and so forth. So the judge may say, would you all wish to consider mediation? And after discussing, conferring with their lawyers, the party may say, fine, yes, we'll go to mediation. Now, if that decision is made, the judge or master would then explain to the parties what mediation involves. Mediation is therefore a process by which an attempt is made to have the matter settled. But there are several very important features of mediation. First of all, it is much less expensive than a full-blown trial, in that the parties pay right now, the level of fees are $400 each as the mediator's fees, and those fees are fixed in the rules of court. Whereas if a matter goes to court for a day, 2 days, then legal fees will mount up, and no lawyer is going to charge $400 for handling a matter in court for a day, or even part of a day. And therefore, economy is one of the first benefits of mediation. You save a lot of money. But the beauty about mediation is this: the parties are allowed to make statements discussing their case before the mediator without being bound by those statements if the mediation breaks down and the matter has to go back to the court for trial. Because if the mediation attempt does not succeed, then it means that the parties will then go to a full trial to hear the matter by the giving of evidence and the examination of documents and other exhibits. So that parties encouraged to compromise. One very important aspect of court-appointed mediation is this: mediation is not for the lawyers. Mediation is for the parties themselves. And in fact, I know some lawyers who don't physically like to be present in the mediation. And I know some mediators who would prefer not to have lawyers in the same room at the same time. It is not the lawyers who have to make compromises and so on. It's the parties themselves. So this is what happens. There is a room in the courthouse called the mediation room. It has a long table. The mediator sits at the top of the table, and the parties sit on either side of the table, with or without their lawyers. The mediator would encourage them to give their point of view. He would listen, he or she, because a lot of mediators are female. And I will tell you about how to become mediators in a while. So the mediator would listen to one side, then the mediator would invite the other side to talk. They will say what their point of view is, because the mediator is trying to see in what way these persons can settle their differences. After a while, the mediator sends one side outside the room and discusses the case with the remaining party. Then the mediator will then ask that party to go outside, and he will bring back in the first party and speak to them confidentially in private, trying to work out exactly what are the differences between these persons, trying to work out what will it take to bring them together to solve that problem and settle that dispute. And then when the mediator would have listened to both sides privately, he listens to them together. Now, the mediator's role is not one of forcing the parties to agree, but his role is to encourage them to agree. Big difference. He is not by his conduct to show whose side he is more inclined to support. He's not supposed to take sides, but he is supposed to encourage these people, having listened to them privately and publicly, as it were. He would know exactly what is in their mind, and he will try to nudge them to see things in a particular way. Now let us be optimistic and say, eventually, the parties decide, yes, we come to a settlement. The mediator will record the terms of the settlement. What have they agreed? He'll explain it to both sides and make sure they understand what it is they're agreeing to. And then the mediator would send a report back to the judge. Telling the judge, yes, these parties have agreed to settle their differences along the following lines. And then a date would be set for the parties to appear before the judge, for the judge to certify that they agreed with the mediation report, and generally that would be that. The matter judge will enter what is called a consent order. But there are cases where mediation does not succeed. One side may get on the high horse and feel they're not agreeing to this, and one side may behave in a very intransigent manner. And you know, there are some people who don't know what it is to give up their rights for peace, as the old people used to say. So where mediation fails, the mediator, having tried his or her best to get the parties to settle the matter, and seeing that the parties have no intention of settling, he enters in the book, he writes a report, mediation has failed. And he sends the matter back to the judge. So, look, I've tried my best, but the parties cannot see eye to eye. They cannot agree. And the judge would then, at another hearing, set the matter down for a trial. Now, the mediator cannot disclose to the judge or to anybody else what it is the parties discussed. So what happens in a mediation is confidential. Therefore, when the matter goes back before the judge, the judge will have no idea who was being stubborn and who was being unreasonable, or on the other hand, who was being pliable and reasonable. The judge will simply say, they tried to settle, they didn't, and therefore put the case down for trial. And when the trial is held, evidence is given, and the judge makes a ruling as to who wins and who loses. And in most civil cases in the High Court, somebody loses. You seldom have a case where people come out with a draw. It's usually one side loses or the other side loses. And the general rule is that the losing side pays the costs, the legal expenses, not only for himself, but for the other side. So when you decide that you're not going to settle a matter at mediation, you're running the risk that if it goes to trial, you could lose in the trial and face an enormous bill. Now, mediators are persons trained to be mediators. Most mediators happen to be lawyers, but not necessarily. There are many mediators who are not lawyers. You don't have to be a lawyer. And every now and then you would hear an advertisement that there's a mediation session where people are invited to come for training. And the judges lecture you and so on. And eventually you get certificates. As if you read the newspapers a few weeks ago, you saw a photograph of lots of people who had just passed the mediation training. So a mediator hasn't got to be a lawyer. And as I said before, most of them are now women. As you would find in most areas of public administration, women are tending to dominate the scene. Now, the mediators provide a service, because who is going to think that $800 could compensate a busy lawyer giving up sometimes a whole day to attempt a mediation, whether the mediation is successful or not? $800 a day cannot pay a lawyer. And they don't get any salary. They simply get the mediation allowance. So they are providing a service. But that service is part of what is called alternative dispute resolution, ADR, where in the last 30 or 40 years, legal systems throughout the world are trying or have been trying to devise ways and means of having people resolve their disputes without having to go to trial. Because apart from the expense, which I mentioned, trials tend to be traumatic. They tend to be stressful. And if you have a matter in court going on for any length of time, you wouldn't know what it is. You keep going back to court for this or that hearing, this or that procedural matter, and the time comes and you're tired, you're fed up of going to court. Meanwhile, the stress builds up. And therefore, there are many advantages to trying to solve the matter, settle the matter peacefully by mediation rather than going to a trial. If all else fails and the parties can't agree, then so be it. The mediator would have tried his or her best, and the judge would then send the matter to trial, will then try the matter, and who wins, wins, who loses, loses. That is the essence of court-appointed mediation, a process supervised by the court, by which the court encourages parties to settle their problems. But the old people say, and the saying is, that you can force a horse to go to the riverside, but you cannot force the horse to drink water. And therefore, many persons take advantage of mediation, many persons don't. But I can tell you from my own personal experience, it is always better for parties to have a matter settled where they have the opportunity than to run the risk of a trial. Because for one thing, at the end of the trial, if you lose, you would bawl when you hear what costs you have to pay. You say, oh God, I didn't know, and so on. You can't bawl and scream and say you didn't know. You really ought to have some knowledge that these things are expensive. The system is working in St. Vincent and Grenadines. And I would just end this program by encouraging anyone who has a matter in court to discuss the possibility of mediation with his or her lawyer if it isn't too late for that. The lawyer would explain to you the pros and cons of mediation, and in most cases you would see the wisdom of mediation. One African proverb is that ja is better than war. In other words, it's better to talk through a problem than fight over the problem. All right? Perhaps one of these days I will return to the subject of mediation, but it's quite fascinating. So that is all from this program of The Law and You, program number 925. I look forward to being of further service to you next week, Monday Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week listening to the budget speeches from Parliament. Budget is this afternoon. In fact, as I speak, recording this program, the formalities of the courthouse, the House of Assembly, I should say, would be on the way. Until then, may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.